Is that his retirement pose?
You can hear me, I think. Start video. Yeah, my camera is on.
Like, there you are. No, you flashed on and off there, Robert. There you are. Why did I think you were retired?
Yeah, well, I thought so too, but
Yeah. Okay. Yeah. Well, we'll get the story someday. All right. You're up.
Okay, good morning, Your Honors. I'm Robert Donald from Fort Myers, and I'm here on behalf of the former husband, Greg Toth, the appellant in this case, posed by Stacy Sherman. Stacy's here on behalf of the former wife, and I would like to reserve 5 minutes for rebuttal if I may.
Sure.
The case has a long history before this court, at least 3 different appearances. Fortunately or unfortunately, depending upon the way you look at it, much of this is irrelevant. In January of this year, a panel of the court PCA'd the appeal from the second amended final judgment of dissolution of marriage. Judge Rothstein Joachim was on that panel. So the second amended final judgment of dissolution is final, enforceable, no further attacks possible, and we are not attacking that judgment in any way. These consolidated appeals actually challenge 4 orders entered after the second amended final judgment of dissolution, purporting to enforce that second amended final judgment of dissolution. As I said, our arguments today will assume that that second amended final judgment controls as it must. And I'm aware that there's such a thing as adjudication fatigue, especially where there's a bunch of convoluted facts as there were in the divorce part of this case. But the 4 orders that we're challenging here today are only minimally factually intense or relevant. Basically, these are legal issues that we've raised, and what we want the court to do is look closely at what happened after the final judgment, which made a grossly uneven distribution in favor of the former wife. But these 4 post-judgment orders have piled on there and increased the disparity between the two. And in the course of doing so, in our opinion, has transgressed several well-established rules of law. There's 4 orders, and what I would like to do today, because of our limited time, is talk about each of the 4 orders rather than necessary particular points on appeal. And the first order I want to start with is actually the second order that is discussed in our initial and reply briefs. And that order is the final money judgment purporting to enforce the second amended final judgment. The second amended final judgment gives the husband 60 days to pay an equalizer payment plus some other money. It's not just equalizer, but it totals over $1 million. And he's got 60 days to pay that. But the important part for present purposes is what's found in paragraph 33 of the second amended judgment. And that says, quote, the husband may either convey to the wife assets valuing the amount owed, or otherwise sell his interest in said assets in order to raise the money necessary to fully comply with this second amended final judgment in a timely manner. Please note the disjunctive, either or. The former husband has 2 choices. He can convey property, or he can, on his own, supposedly sell that property and use the funds to pay. In practical effect, he didn't have this second choice because all of the property in question are these small minority interest in real estate partnerships that are encumbered with first rights to purchase, lengthy periods of consideration by the other partners, and prohibitions of selling to non-partners. So the former husband really couldn't sell the property, and he certainly couldn't sell it within 60 days. But because the former wife was herself a partner, he could take advantage of that first of these two choices and convey the property to her, which is what he did. He executed documents conveying over $1 million worth of property to the former wife. Well, she refused to accept it. Okay. And she told the trial court what she wanted instead was a money judgment, which is what the trial court ended up giving her, was a money judgment. She's used this money judgment to get charging liens on all this property, to garnish all kind of other property, and essentially make it impossible for the former husband to earn a living and put liens upon any assets he has, so he can't sell or borrow against those assets. Again, it was a disjunctive choice given to the former husband in the second amended final judgment. And as the court well knows, when property rights are decided in a final judgment of dissolution, those property rights become vested, and they can't be altered by a trial court afterwards in the context of either enforcing or doing anything else. It really becomes a jurisdictional question. It's in essence, modifying a judgment that has become final and unassailable. What the trial court did here was it removed one of the possibilities for the husband, much to his detriment. He did this in 2017. The trial court refused to recognize it, ran the interest back commencing in 2015, and I did a search of what the interest rates have been since 2015, and they've been at a high of 6.89, a low of 4.75. So the interest on this money since 2005 is like $300,000 because interest is running on it, because the trial court would not allow the former husband to exercise his vested prerogative to transfer the property to the former wife. One of the cases on this is, Judge Northcutt, your opinion in the Bridges case from 2003. The facts aren't very similar. In Bridges, what happened is the judgment awarded the former husband some personal property that was in the wife's possession. She didn't give him the personal property, and he moved to enforce the judgment. And the judge said, yeah, well, you are entitled to the personal property, but instead, I'm just going to give you a money judgment against the former wife for that amount. And you said, no, you can't do that. There's a vested property right there that you cannot disturb later on in the guise of enforcing it or something. I filed a notice of supplemental authority here recently because about 10 days ago, Judge Black authored the Springer decision, which relies upon the Bridges case and holding, and wouldn't you know it, a dog. The husband's awarded the dog. The wife doesn't give him the dog. The husband moves to enforce. The court says, yeah, well, you're entitled to the dog, but what I'm going to do is I'm just going to give you a judgment against the wife for the $15 the dog is worth. And Judge Black cited back to your Bridges case and a number of other cases that state you can't change the judgment in the guise of enforcing it. If the judgment gave the former husband two choices, he can't be deprived of one of those choices in a supposed modification proceeding. Another, horrible aspect from the former husband's perspective of this money judgment is the interest issue. The trial court gave the former husband 4 years of free interest, the best I can tell, started the interest running in 2015 rather than in 2019 when the second amended final judgment was entered. Now, The trial court did this, I think, because the amended judgment, which was reversed by this court, was entered in 2015. Okay. The court reversed the amended judgment on a Berg-Perlow violation. And we don't need to go into what that entails, but I think the court knows what it entails. And it's basically the trial court has abdicated its decision-making authority and just allowed one of the parties to make the decision for it. So the former wife accepts that the basic rule is you can't get fees before there's a finding of entitlement, but she says, gee, there's an exception because of this prior appeal. And there is a body of case law on this. It springs from this Novak decision decided by Supreme Court back in 1968. And the big case on it is really the Guy v. Knight decision decided by the 5th DCA. And what these decisions and their progeny say is if there's a reversal on appeal for some ministerial reason, and of course the best example of that is if a jury enters a verdict and then the trial court overturns the jury verdict, but on appeal it gets reinstated, then all that happens upon reversal is the trial court enters the judgment it should have entered to begin with. Yes, interest can run from that date because it's just a ministerial action. There's no judicial labor required upon remand. Obviously, in a Berg-Perlow situation, it's the epitome of judicial labor being required upon remand. What a Berg-Perlow reversal is judge, you did not exercise any discretion. You did not apply judicial labor in the first instance. So upon remand, you've got to apply the judicial labor to decide this case in an independent and thoughtful manner. So there's really no way for the former wife to crawl under that exception to the general rule. And like I said,
if we agree with your argument about the propriety of the money judgment altogether, this issue goes away, correct, Mr.
Sure,
Dawson?
that's correct. If you buy the first one, and then he paid the judgment off in 2017.
And there's no interest.
Yeah, then we're not talking about any interest. But even that, like I said, is sort of piling on here. I mean, relating it back to 2015 digs a hole for the husband that he can never get out, and that's the problem. Another problem with the money judgment is it fails to give the former husband credit for the $240,000 that was garnished from him under the amended final judgment that was reversed. And again, to add insult to injury, not only doesn't it give him credit for that $240,000, but interest on that $240,000 runs the whole time, pumping that $240,000 up to an even larger number. There simply is no basis not to give him credit for that money that was garnished from him and paid to the former wife. There's no dispute about it. I mean, everybody admitted. In fact, the trial judge said at the hearing, I'm spreading it on the record. You're going to get credit for it. Yet the judge signed the former wife's proposed order that did not give him credit for it. Okay. So the former husband, has taken a $240,000 plus hit by not getting credit for that amount that was garnished from him. What I'd like to do now, and let me see how I'm doing time-wise here. I think I got a little bit left, is turn to the fee judgment, which, is another huge hit for the former husband that's devastating for him. It took a long time in the trial court to figure out the former wife's basis for fees. She didn't plead any basis. She just said she wanted fees and didn't plead a basis for it. She said at trial she wasn't seeking 6116 fees, okay? In the prior appeals, we sort of narrowed down that the only possible way she could be seeking fees would be on the inequitable conduct doctrine a la Moakley and Bitterman in that line of cases. Of course, this was not known at the time of trial. At 4:30 on Friday afternoon, when the trial was getting ready to end, the former wife's counsel said, and I quote, "We're asking for a separate hearing on that," unquote, referring to attorney's fees. The trial court responded, "We will definitely reserve on that problem," unquote. There was no further discussion of fees, nor was there any argument on fees. Yet when the former wife sent a proposed judgment to the trial court, it had a finding of entitlement for her in there, and the trial judge signed that proposed judgment and has perpetuated in all of the judgments it's entered since then. So even though there was an understanding at the conclusion of trial that there would be no finding on fees, no adjudication of the fee issue, the trial court went ahead at the former wife's prompting and adjudicated entitlement.
We're right at the closing in on your rebuttal time, Mr. Donald, but I wanted to ask you, how do you respond to the wife's assertion that that reservation was really only as to the amount?
I don't know where she gets that from. There, like the word bifurcation or any synonym of bifurcation or any indirect mention of bifurcation is not mentioned anywhere. She refers to the pre-trial statements of the parties, and boy, I'd love you to look at those pre-trial statements, because what the former wife's counsel says in the pre-trial statement is that the fee issue will be decided at trial or at a subsequent hearing. That's what it says. The former husband's pre-trial says fee issue should be decided at a subsequent hearing. Again, neither one of them talk about bifurcation or some part of it to be decided. They talk about that the issue will either be decided at trial or thereafter, not a little bit of both, okay? And remember,
at that time, had the basis for the fee request been narrowed down to the inequitable conduct doctrine, or were you still kind of up in the air about it, or do you know?
yes, again, we got time frames here, but basically the discussion with the trial court about reserving jurisdiction was at the conclusion of trial.
Right.
Moakley, Bitterman, or no other case involving attorney's fees for bad conduct had ever been cited by the former wife. When she did her proposed judgment, she put several cases in there, some of which were Rosen cases, some of which were inequitable conduct. Certainly not at that time, no.
Okay. Since I butted in on your time right at the start of your 5 minutes, I'll still give you 5 minute rebuttal if you want to stop right now.
I guess I'll stop right now.
I'll make you an offer. I'll say you have 5 minutes to go. Use them as you please. How's that?
Okay, thank you, Your Honor.
Good thing. Ms. Haverfield?
Thank you. Good morning, still morning. May it please the court, my name is Stacey Haverfield, and as Mr. Donald said, I have the pleasure of representing the former wife, appellee, in this post-judgment divorce appeal. To reiterate, this court affirmed in total the second amended final judgment from which these orders that are currently challenged in this appeal stem. I'd like to take the reverse order of Mr. Donald in discussing some of the points on appeal. There were 16 issues raised, 15 now, one went away, and I can't get to all 15, but I'll hit hopefully some high points unless someone wants to direct me to a specific issue. At the end of the day, the trial court got it right. I mean, you're going to hear all sorts of things about piling on and how, people had to pay, but really, this trial took way longer than it should have, primarily and specifically because of the behavior of the former husband. Let me take you back. He filed a petition for dissolution in 2009. In 2015, the parties finally went to trial. There were no children born. No one was seeking alimony. And they were able to distribute per an agreement right at the very beginning, within a month of filing, all of the properties and assets that had a positive value. So really all that was left were these properties that required continuous and ongoing payments. And the former wife had her name on a lot of these. She was either the personal guarantor, or she was liened in some way, or they were involved in her business, so she naturally had a vested interest, whereas the former husband did not. And therefore she was stuck paying for the pendency of the trial period all of these ongoing payments, which were substantial sums. She sought multiple times the court's assistance by filing motions to enforce and compel, trying to set hearings, and repeatedly, despite also receiving source documents directly from the financial institutions or from the companies themselves, the former husband repeatedly reported to the trial court that he did not receive the discovery. And it was later determined that he in fact did receive it multiple times. And this unfortunately created some significant delay, large expenses, and a great deal of attorney's fees.
Are the attorney fees subject to being awarded in this domestic relations proceeding by a computation of the hourly rate, by the number of hours that were necessitated to be used by counsel to do this, and then applying the factors in 6116, need and ability to pay?
So let me address those in order.
Well, wouldn't that be the norm?
Yes. And in this particular situation, both parties agreed that they were not going to seek fees pursuant to 6116. In fact, in the pretrial statements that Mr. Donald referenced, both parties acknowledged that these fees being sought were specifically as a sanction against the former husband for his protracted litigation. And at the time of the hearing, to now bring us to issue number one, entitlement.
I don't mean to disagree with the Supreme Court of Florida in Mowgli, but let me present my concern nonetheless. It would appear that the trial court's inherent authority to punish at its root origin is the ability to punish the attorney that appears before the trial court at that time, because the attorney is licensed in the state of Florida and is an officer of the court. I will concede readily that appears to be some language in the Supreme Court opinion that bleeds on to count to the party, but I'm concerned about whether the trial court has inherent authority absent a contempt citation, due process, and then findings to do what was done here. You come in at the end of the case and say, now I'm going to find it to be willful. When was anyone put on notice of that?
Well, I would suggest that they were. And there is a reason why the inequitable conduct doctrine is supposed to be very sparingly used. So we agree with you there. But this
if
is
you agree not to do it under 16, and we go through the list of checklist in Mowgli, do the statute, then the rules, and the rare and limited six, have we run out of spots if you're indicating that you have elected not to proceed under the statute, which might provide you an ability to get fees?
We think that the inequitable conduct doctrine in this particular circumstance, given the long egregious behavior and purposeful, this was purposeful behavior, that this fills a gap, that 6116 does not fill, that Rosen does not fill. And so that circles back to the no need for the need and ability to pay analysis, because if it is, then folks like the former husband are going to be able to shield themselves from bad behavior based on an inferior financial position. Here, again, the parties.
I guess my concern is not so much on the back end of the punishment. My concern is on the front end, the trial court's authority and/or what nature of due process notice needs to be provided when one is going to do that to a party who's willfully behaved. If parties have reserved, then it's when you come back at the next hearing, you say, this is like the procedure. We're alleging this was willful to bring it within this narrow exception. My concern is more about authority and/or procedure.
I think that the Mowgli line of cases give the trial court the authority to be used sparingly, and we agree, to sanction a party for egregious, repeated, bad faith conduct. As far as notice, the parties were on notice the former wife filed no less than 3 motions to enforce and to compel compliance with the 2010 order. In each one of those motions, there was a prayer for attorney's fees. Both parties acknowledged in their respective pretrial statements that 6116 fees were not being sought, rather fees were being sought for the bad faith conduct of the former husband. So once again, notice. Now, whether or not the parties—
Does the limitation under those motions reply only to the extra hours that were caused by, or does that allow them to pursue the totality of attorney fees?
The trial counsel and the trial judge in this particular situation took the position that it only allows for those fees that were directly related to
The conduct.
the conduct. And that is indeed what happened. The trial attorney, as well as the experts, sectioned off and eliminated those time entries and fees and costs that were not associated with the bad faith conduct and trying to compel compliance. So they did segregate. This was not an award of all of her fees. I mean, that's frightening in and of itself, because we're talking about an award of $111,000, but that was over a period of 2009 to 2015. And again, in the second amended final judgment, the trial court made mention of this. I mean, this was repeated. The former wife kept trying over and over again to get these motions heard, to get these issues before the court so that they could be resolved pre-trial. And the former husband was quite successful in creating delay. The other interesting thing about this is the appellant wants you to take that statement, rip it out of the trial, and hold it off to the side in a vacuum. And we would suggest that that's not the way to view this. You have to view it in total. So you view the pretrial statements, and did the parties know that this was something that was either going to be sought at the time of trial or was going to be sought at some time after trial? 1. 2, the former husband's trial attorney is a very well-seasoned family law attorney. And as we know, fees are a commonly litigated subject matter in family law. And so upon receiving the amended final judgment where—
Yes, indeed. Fees is the first time I got to meet Judge Northcutt.
Oh, well, so it brings people together too. So
He reminds me of that constantly.
well, but here we are, the trial attorney, if this was a surprise and folks didn't know what was going on, then the trial attorney would have likely brought it to the trial court's attention. Hey, this was reserved too. The former husband's trial attorney had the receipt of the proposed amended final judgment, a motion for rehearing where he didn't raise it, all the documents that were filed between June 2015 and the evidentiary hearing on the amount of fees alone in January 2016. He never brought it up. He didn't bring it up at the evidentiary hearing on the amount of fees. He also did not bring it up following the evidentiary hearing on the amount of fees when he filed his motion for rehearing. The first we're hearing that entitlement was also reserved is in the initial brief. And so why? Well, because everybody knew that that was an issue that was being tried, because it was part and parcel. Even in former wife's counsel's opening statement, he says, I'm paraphrasing, but he says something to the effect of, just remember, we're seeking reimbursement for these fees, and intertwined with that is the actions that we had to go through to compel the former husband's behavior and the former husband's bad faith conduct that created such a level of delay and increased costs that the former wife exhausted all of her assets. They are part and parcel. They are intertwined and they are together. That was not the case. Entitlement was properly before the court. The court exercised its, albeit limited, but still nonetheless authority to fill in a gap. Because again, these fees and the length of time that it took were solely due to the purposeful and intentional litigation tactics of the former husband. I mean, the former husband repeatedly took contrary positions. He repeatedly misrepresented the documents he had to the trial court. He repeatedly asked for continuances and then requested documents over and over and over again. He failed to admit that he received the documents from the source themselves. So all of this, and then the ignoring the flagrant
Then we should
violation.
have to spend your time on that one issue. I read the briefs about what he didn't do, so I'm familiar with that.
Okay, well, thank you. I appreciate that. Well, so as far as an entitlement goes, we take the position that it was properly before the court, that due process was afforded, and we should move along from there. I don't know if I apologize. I don't know if I heard you say that I'm out of time or.
I'm not running the clock today, so
Oh,
you're
okay.
safe. It's Judge Northcutt.
Oh, very good. Okay, so I'll press on unless you tell me to stop. So, oh, you're muted, Judge Northcutt.
He's not ready to tell you yet.
Oh, okay.
You're
Okay.
muted, Judge Northcutt. Still.
Steve is muted. Steve, you're muted.
Boom, sorry, my Zoom screen got lost in all of my windows here. You have about 8 minutes to go, Ms. Haverfield.
Very good. I'll press on then. Thank you.
Please do.
Okay, so I'm taking the issues from last to then first. So I believe that the next issue, and I'm gonna combine these together, the credit of the 239 as well as the interest on the final money judgment. The trial court took the position, because of how this court wrote its opinion from the first reversal of the amended final judgment, that it was to embark upon the ministerial task of drafting the amended final judgment to be the second amended final judgment, exercising its independent decision making. There were no additional submissions. There were no additional hearings. The council got together and provided the trial court with all of the records, including the transcripts, all the briefing, et cetera. And then it was his job to go back and produce what it was now the second amended final judgment. That was a ministerial act. And so even though it was under Berg-Perlow, and we recognize the import of that, and we don't mean to minimize ministerial acts. I'm not trying to rank substantive performance and judicial labor over ministerial acts, but this was indeed a ministerial act by the trial court. It involved none of the parties, because the direction in the opinion was for the trial court to go back and draft a final judgment that reflected his independent decision making.
The argument there is that to have another evidentiary hearing or whatever would have been beyond the mandate, correct?
That is correct.
Did the judge express any need to have additional evidence?
It's interesting you bring that up. We did have a case management conference to allow everyone to get together. That the transcript from that case management conference is located in the record. At the case management conference, the trial court heard all of our arguments and decided that he was going to do this in a step-by-step process. So first, he wanted delivery of all of the documents, transcripts, records, briefs. We gave him CDs of oral argument. We gave him the initial proposed judgments from both parties. And then he was to take that back with the understanding that if he needed or wanted more information, he was going to call us back in and tell us exactly what he needed. He didn't need more information. And keep in mind that the trial court had been involved in this case since 2011. And at this point now it's 2019. So he was very familiar with what was going on and the ins and outs and what property was involved and the different legal determinations that need to be made. So the trial court took the position that he was supposed to utilize that information and then produce a final judgment based on that information. The credit occurred 2 years after. And what's interesting about the credit is the appellant is correct. Everyone acknowledges it. In fact, it is spread about the record that this $239,000 was paid for. And it is, I think the record page number is 402 in the supplemental post-judgment record, where it shows an interest list, and the 239 is listed right on there and is deducted. So this idea that interest is still collecting on the 239 is just inaccurate. But the trial court acknowledged it in the transcript. It's been mentioned many times. And much like what happens in post-judgment collection type matters, you get the judgment first. It may be paid off in parts or it may be paid off in whole, but that's done after. So naturally, that information is not going to be included in that initial final money judgment. But that is of no moment He is receiving credit. The process is performing as it should. And there's no reason to reverse the final money judgment for failure to put that figure in the final money judgment. Again, same thing with the interest. And I know interest was also discussed as far as the attorney's fees. And it's the same argument. The trial court wanted the opportunity. I mean, the trial court took this seriously. It wanted the opportunity to go back and create the final judgment that this court requested using his own decision-making and independent decision-making authority. And that's exactly what the trial court did. And so to include things and events that occurred after in the trial court's position and in our position would have gone beyond the mandate. And the court did not want to do that. As far as the 60 days, I want
All right, let me get the order of events here. So there was the initial judgment taken on appeal, or initial amended judgment, I guess, taken on appeal.
Yes.
It gets reversed. The judge enters a new second amended judgment. In the interim, there was this garnishment. Is that
Yes,
correct?
Yes.
Okay, so you're saying that the judge should not, since this was essentially like a nunc-pro-tunc back to what he should have been doing before, it was appropriate not to reflect the garnishment in that second amended judgment.
Yes, sir. And in furtherance of that, the judge actually writes on the second amended final judgment at the end, nunc-pro-tunc, back to June 2015. So we know that was his understanding. It doesn't mean that it isn't acknowledged. And I wrote the number of times that the 239 that's talked about is mentioned. 1, 2, 3, 4, 5, 6, 7, 8. So 8 different pages in the record. So this 239 credit has been acknowledged by everybody. No one's hiding from it. The fact that it's not included in the final money judgment is of no moment, because the court was trying to comply with the mandate of this court. And in doing so, as you point out, Judge Northcutt dated everything back to when this court said he should have engaged in his independent decision-making.
Okay.
And then as far as the 60 days, that in our opinion is a misrepresentation of what the court afforded the former husband. The court afforded the former husband the ability to pay cash to satisfy the equalizer payment, or the ability to transfer property assets that valued the equalizer payment, not to randomly pick assets that he think might but not prove up. And so despite being afforded the opportunity to prove up those assets, to make sure that they valued the $1,046,000, which was the equalizer payment, he elected not to. He just wanted to transfer those assets. This was not a modification by any means. This was an enforcement. And because he didn't produce the property and or a cash payment that valued the equalizer payment within 60 days, then the money judgment was entered. The trial court did not err there. He was perfectly within his authority to do what he did. At the end of the day, the trial court got it right. I mean, these orders are based in the record, they're based in the law, and at some point, we have to bring this matter to a close, and we're hoping it's with this. Because the trial court got it right, we're asking that you affirm the challenged orders on appeal. Thank you.
Thank you, Ms. Haverfield. Mr. Donald?
Let me get unmuted here. Thank you, Your Honors. Ms. Haverfield wants to go back and talk about the trial, and I thought we had decided that the second amended final judgment, it's there, it's binding on us. We don't need to talk about that, but she wants to talk about it. The reason it took 4 years to try the case is because the husband was hospitalized 7 times in that period. They both changed lawyers and changed experts during that period. And as you know, this was an extremely complicated property case. So, you know, there's reasons it took so long, and that issue is completely irrelevant to what we're doing here. Judge Casanueva, I think you hit on, you know, in an abstract way, the most interesting issue in this case is whether Moakley can even apply in a divorce case, okay? It should not apply in a divorce case, because what it is it's used here as a perfect example. It's an end run around 6116. The legislature controls divorce cases. Now, if there's
Oh, when
nothing,
Mowgli came out, it was 2002, and it is a divorce case, isn't it?
I don't think it's Mowgli v. Smallwood. I can't remember. I don't really know.
I thought it came out of a dissolution proceeding. I
It
could be
may
wrong.
have been post, people keep their names, plus it could be post judgment. I don't know. But in any event,
But to follow up on what Judge Castanueva was saying, doesn't Mowgli refer and sort of build on Bitterman versus Bitterman,
yes.
which I think was a dissolution case, and the only issue in Mowgli, I thought, extended the inequitable conduct doctrine from the parties to the attorneys. Am I
That's
remembering
in general
correctly?
my understanding, yes. But the difference is, remember, we've got the Rosen gloss on 6116, and the inequitable conduct doctrine and the Rosen doctrine are the same. The only difference is need and ability to pay applies under Rosen in 6116. So this is an end run around the need and ability to pay. I want to be quick here because I don't have much time. Ms.
Got
Haverfield,
about 3 minutes, Mr. Donald.
Ms. Haverfield made some wonderful findings here for the trial court about how dastardly the former husband is. But I asked the court to read what the trial court himself said. One of the problems is Mowgli applies here. The trial court did not make the findings required for Mowgli. Ms. Haverfield maybe has made those findings, but she's not the court. She also says that judicial labor was not expended because no evidence was taken. Isn't this panel expending judicial labor today? Judicial labor means judges expending labor. Isn't that what you're doing? Isn't that what the judge did when it had to reevaluate all the special equity issues, all the issues in this case, to say that was not applying judicial labor it seems to me is sort of ridiculous. I mean, it doesn't carry any weight. Okay. Ms. Haverfield says the pretrial compliances talk about sanctions. I don't recall them mentioning sanctions. Okay. Recall that the former wife sought 6116 fees in her pleading. And I think all that the pretrial compliances say is her claim for fees. It doesn't say on what basis. But whatever it says, it doesn't mention the inequitable conduct doctrine a la Mowgli and Bitterman in those cases. Ms. Haverfield also talks about the disjunctive choice the former husband had. The first final money judgment that got reversed, the former wife's counsel put an expression in there that said, well, I didn't really mean what I said. And quite frankly, it was nonsensical. It makes no sense. The second, and that got reversed. Then when we come back again, the former wife drafts a new order for the judge to sign, and maybe realizing that didn't make any sense, took that provision out, and the trial court signed that provision. Now they say something about value. Certainly the former husband transferred something to the wife he should get credit for. And the former husband used the valuations assigned by the former wife, her exhibit C in evidence, which the trial court references in paragraph 24 of its second amended judgment, says the parties established the valuation of that stuff they distributed, and exhibit C by the wife shows the current value of those things. That's what the husband used in transferring property to the wife. So
your position,
Go ahead, Judge Rothstein. You come.
thank you. So your position is, even if it didn't cover the entire amount, it covered at least part of it. And
Yes. He had to get a credit for something there. He can't get miffed or whiffed there. Okay, the 239,
Okay.
I want to mention that because that's
Yeah, but you need to go ahead and wrap up, Mr. Donald.
I'm going
because
to
you're-
the last point.
Okay.
239, that was paid before the entry of the judgment. So it's like a set off. If he.
Well, I get that, but this was paid before entry of the second amended judgment,
Yeah.
correct? Yeah, no, I understand the scenario there.
I mean, you've got to give him a credit for that. And recall also he tried in the alternative to undo the garnishment, and the judge denied that. And you know this, if this court were to affirm this upon remand, the former wife's counsel will say, hey, he don't get no credit for the 239. They raised that on appeal in the second district, disregarded that. He don't get no credit for the 239.
Right.
So their magnanimity that we see here would not be reflected upon a remand if this court doesn't fix that.
Okay, your time's up, Mr. Donald. And if y'all are wondering what I'm doing when I'm doing this, I'm telling a dog to shut up. So,
I can't hear it, but
yeah, I can, unfortunately. Thank you both very much. It's all.
Thank you.
You know what? I don't know how many Zoom courts we've had. When I put them in their crates, they shut up for some reason today. I think it's Mr. Donald's voice really, but for some reason today, they're in there whining and barking. So thank you both very much. It's always a pleasure to see both of you.
Thank you.
Even Mr. Donald's kind of like an old penny coming back. So we'll see you again soon. In order to leave this court, you click the leave button in the lower right-hand corner of your Zoom screen.
okay.
Thank
See
you.
y'all. Thank you.